Hello, my name is Ruby and welcome to the International Business and Law program. Today, we will further discuss competition laws in order to investigate the case study of Roland Machinery and Dresser Industries. First, let's talk about the Sherman Act of 1890. The Sherman Antitrust Act of 1890 is a U.S. legislation that outlawed groups of businesses that either team up to have formed a monopoly or in order to gain control of the pricing in a particular market. So, does anyone know the purpose of this act then? Turin?
Ultimately, the act proposed was to promote economic fairness and regulate competitiveness. However, in Section 2 of the Sherman Act, was particularly designed to attack monopolies, deeming those who monopolize, attempt to, or conspire to monopolize any part of trade or commerce among several states is guilty of felony.
And you have anything to add?
Similarly, the Clayton Act that was passed in 1914 attacked specific practices that monopolists traditionally do to gain monopoly power. Section 3 of the Clayton Act attacks three kinds of anti-competitive behavior: tie-in contracts, exclusive dealing contracts, and requirement contracts.
Khanh, can you tell us more about the tie-in contract?
Alright, so the tie-in contracts occurs when a party sells one product, but only on the conditions that the buyers also purchase a different products. They are considered illegal under Section 3 of the Sherman Act if 1. The seller has monopoly power in the tie-in products, or 2. The seller has foreclosed competitors from a substantial volume of commerce in the tie-in products.
And what about exclusive dealing contract, Ms. Sri?
Obviously, an exclusive dealing contract occurs when a buyer agrees to purchase all or most of its requirement from the particular seller or vice versa. The seller agrees to sell all of most of its output or products or service exclusively to a particular buyer.
And what about the requirement contract, Mr. Hu?
Yeah, the requirement contract is created when a buyer agrees to purchase on its needed in a certain product from one seller.
So now that we have gotten to know some of the theories, let's dive into the facts. Roland, a substantial dealer in construction equipment, was for many years the area's exclusive distributor of international Harvester consumption equipment. After buying Harvester's construction equipment division, Dresser signed a dealership agreement with Roland. The agreement was terminable at will by either party on 90 days' notice. It did not contain an exclusive dealing clause, and 8 months later, Roland signed a similar agreement with Komatsu. And several months after that, discovering this, Dresser gave notice to Roland of its intention to determine its dealership. Roland argued that Dresser's decision to determine the dealership demonstrated the existence of an implied exclusive dealing contract in violation of Section 3 of the Clayton Act. So the issue here is, did Dresser and Roland have an illegal exclusive dealing contract? Please discuss.
It says clearly here that Dresser and Roland's agreement does not contain an exclusive dealing clause.
However, even if there was such an agreement, it's unlikely that it's anti-competitive. Such as an agreement should be examined but with reasoning.
So then how do we determine that it is illegal, but is considered anti-competitive or competitive?
Well, I think it is strange of Roland to argue that Dresser's decisions to terminate the dealership is an implied exclusive dealing contracts in violation of Section 3 of the Clayton Act, because nothing in the agreement hinted of such an exclusive contract.
Yeah, I agree with you, Khanh. Even the fact that Roland applied for a dealership with Komatsu suggests Roland did not believe they had such commitment.
The agreement between Roland and Dresser would only be illegal if two things are being shown. First, it must prove that at least one significant competitor is excluded from the relevant market, but no evidence suggests that Komatsu is excluded. And secondly, it must be shown that the price of the product
that is actually all correct. To elaborate on Ms. Chi's question, the contract between Roland and Dresser would be determined as non-exclusive, and this gives the parties the rights to also contract with other parties with the same goods and services. And thank you for your decision. All of your opinions are very valuable and wonderful, but now let's return to the case, and the final decision, or the decision we've all came up with for Roland Machinery v. Dresser Industry, is a no. Roland would have to show both that there was an agreement not to carry equipment competitive with Dressers, and that the agreement was likely to have a substantial anti-competitive effect. Nothing in the dealership agreement hints of such an agreement, and like Mr. Ho said, the fact that Roland applied for a dealership with Komatsu suggests that they themselves did not even believe they had such a commitment. And Dresser's hostility to dealers that carried other manufacturers' product does not establish such an agreement either. However, even if there was an agreement, like you said, it is unlikely it would be anti-competitive. And under this test, the agreement would be illegal only if two things are shown. First, it must be proved that at least one of the significant competitor is being excluded from the relevant market. And second, it must be shown that the prices are likely to rise above the competition level. Thank you to the International Business and Law Academy for supporting me in researching on the competition law. And I would like to invite Professor Sun up here.
Oh, lovely. Lovely girl. Your presentation about the topic of the Clayton Act. That means concern about the Section 3 of the Clayton Act. Include tie-in contract, exclusive dealing contract, and requirement contract. That is a very interesting topic from you. Thank you very much for your discussion. And thank you.